That's just messy. What? All right. Try it. Pretty sure I saw. Could be wrong. Is that yours? Oh, I saw something fruity. That's why he's just. He doesn't care.
Okay, good morning, everybody. My name is Judge Kim Teresa Malika. You're here today in First Appearance Magistrate Court. Today, you're going to be informed of the charges, and we're going to determine if there's probable cause. Today is not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You have the right to remain silent. Anything you say or do can and will be used against you. You also have a right to an attorney. If you can't afford an attorney, the court will appoint the public defender. For purposes of today, if you can't get your private attorney or have the ability to hire it, we can either reset your case till tomorrow or 1 p.m. today, or you can use the services of the public defender if you fill out an application. If you have a private attorney, please let me know when you step up to the podium. We have Mr. Romero and Mr. Reedy from the Public Defender's Office. Mr. Romero is at the main jail. Mr. Reedy's to my right in the courtroom. And we have Assistant State Attorney Eric Linder here today. We're going to take a couple cases at a turn. I've received messages that Jimmy, Harold, Terry, where are they? And Brittany Jackson and William Hand.
Jerome Harold here.
Who? Jimmy.
Severe Mange.
Okay, what are their names?
William Hand, Your Honor.
Okay, thank you, sir. Okay, Mr. Hand, we'll see you back at 1 o'clock. Mr. Shate, your attorney's gonna be here, okay? Jimmy Terry, is that your name, sir?
Yep.
All right, we'll see you at 1 o'clock. Your attorney will be here then. Brittany Jackson.
All right. Brittany Jackson is here.
Ms. Jackson, your attorney's gonna be here at 1 o'clock. We'll see you then. Thank you. Jimmy, Jimmy, Terry, William Hand, and Brittany Jackson. All resets to 1 o'clock today. Okay, Danielle Terry, please.
No problem, John. Good morning.
Good morning, sir. How are you?
Danielle. Good. Danielle.
Ms. Terry would like to resolve this matter if possible, Your Honor.
Give me 1 moment. Okay, Miss Terry, you have resisting an officer, obstructing without violence, $100 bond, trespass, occupied structure or conveyance. There's gonna be no return to the quick stop at 7955 Miramar Parkway in Miramar, Florida. If you go back there, you'll be arrested. Do you understand?
Okay.
Yes?
Yes.
All right, thank you very much. What say you, State?
The offer be adjudication time served, both counts.
Okay, adjudication time served, $293 in court cost. Does your client want to accept that?
Is that what you'd like to do, Ms. Terry?
Yes.
Okay.
All right, raise your right hand. Do you swear and/or affirm to tell the truth? Yes. Do you swear and/or affirm to tell the truth?
Yes.
Okay, put your hand down. State your full legal name, spell your last name.
My name is Terry, Terry.
All right, I have to ask you a series of questions if you want to admit to the charge today and give up all your rights to a trial. Do you understand?
Were you talking to me or someone else?
I'm talking to you, ma'am.
Okay.
All right, Mr. Reedy, is there an issue here?
Not as far as I could tell, Judge.
Okay. All right, so, Ms. Terry, your attorney, Mr. Reedy, who spoke to you on the phone from the Public Defender's Office, advised me that you want to give up all your rights to a trial. Is that what you want to do?
I thought we had just resolved it.
Okay. Mr.
The
Reedy?
judge has to ask you some questions, Miss Terry, about whether you want to give up your rights or not, and it's not over until the judge accepts your plea. So please listen carefully to her questions and answer them.
And as far as I know you just said that we were resolving it, so why would we be in this mode?
All right, I'm a little bit concerned here, Mr. Reedy, so why don't you speak to her, or we can just send it to Judge Wren, up to you. Okay, ma'am, go to your left, Mr. Reedy is gonna call you. Next one who's at the main jail, call it, Mr. Romero.
Yes, Judge, let me go in a docket then. We can, call Miss Reniqua Porter, Judge. She's here at Maine and is approaching. Come on up, man.
Okay,
She was picked up on a capias, so we don't need Miss Reed for that.
okay. All right, ma'am, so you have operating without a valid DL, $1,000 bond, you failed to appear. I don't know where this was, let me see. North Satellite, Judge Hurley. Operating without a valid license, court finds probable cause. Does she want to resolve it?
She does, Judge.
State, do you have an offer?
Withhold court costs.
Withhold and court costs $293, 6 months to pay, partial payments accepted. Is that what your client wants to do?
She does, Judge.
All right, ma'am, how do you want to plead to operating without a valid DL? Guilty, not guilty, no contest.
No contest?
And you've had enough of time to speak to your attorney, Mr. Romero?
Yes.
All right, withhold of adjudication, court costs $293, 6 months to pay, partial payments. Court takes judicial notice of time served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, you're done with this case except for paying your $293. Thank you.
The next person which would follow her would be Alicia Garcia, Judge. And she's here at Maine, Judge.
Okay, Alicia Garcia, please. Good morning, ma'am. You have operating without a valid DL, unlawful speed, and out-of-county hold for a misdemeanor for, looks like driving while license is suspended or restricted. That's a $713 bond. Bond on count 1 is 25, 2 is no bond required. What say you, defense?
Judge, I just speak with Ms. Garcia. Did advise her I can ask the court to consider an ROR so that Pinellas County can come and pick her up. But she wishes to resolve the matter here in Broward County, so then she's free and clear when she goes to Pinellas.
All right, well, if she doesn't want to resolve it today, I'll ROR her. I'm not gonna have her.
Exactly, and that's what I told her, but she told me she wanted to resolve it, Judge.
Okay, that's fine, because if she wants, I'll ROR her. I don't want her to feel like she has to plea out. Okay, so
I
what,
can ask her again, Judge, but
okay, so what say you, State? What's your offer?
Oh. I don't know if she's listening.
she wants to resolve it, Judge.
The offer's time served, adjudication.
Adjudication, time served, $293 in court costs, 6 months to pay. Partial payments accepted.
She wishes to accept the state's offer, Judge.
All right, ma'am, how do you want to plead to operating without a valid license? Guilty, not guilty, no contest?
No contest?
All right, adjudication, time served, $293 in court costs, 6 months to pay, partial payments accepted. Thank you, ma'am, good luck to you, and the court will dismiss the unlawful speed.
We're ready on Miss Terry, Your Honor.
Okay. All right, let's recall Danielle Terry at North Broward. Good morning, ma'am, how are you?
Fine.
Okay, so what are we doing here, Mr. Reedy?
Miss Terry would like to enter a plea of no contest, give up her right to trial, and accept the state's offer of an adjudication time served, with an understanding that she will not be returning to the area where she was arrested.
Okay. All right, ma'am, so I'm gonna ask you a series of questions, because I just want to make sure you're doing this knowingly, voluntarily, and freely. Do you want to give up all your rights to a trial?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Tell me what you think's going on here today.
in court, and I'm about to leave.
Okay, and you're about to admit to the charge?
I guess so.
Well, you can't guess. You gotta tell me. How do you want to plead to resisting an
I
officer?
think.
Let me finish,
No
ma'am.
contact.
I
Oh,
need,
okay.
I need to finish my question. How do you want to plead to resisting an officer obstructing without violence and trespassing occupied structure or conveyance? Guilty, not guilty, or no contest?
No contact.
Have you ever been treated for a mental illness?
No.
Okay, and you've had enough of time to speak to your attorney, Mr. Reedy, who's in the courtroom and called you on the phone?
Yes.
And you feel that no contest is in your best interest?
Yes.
And you understand that if you go back to this Quick Stop store, you're gonna be arrested?
I heard you.
Okay, do you understand that you can't go back there?
Yes, I understand.
Okay, and you don't intend on going back there, do you?
I don't unless I pass on the bus.
Okay, all right, court's gonna accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea, adjudication time served on each count, $293 in court costs on count 1, 6 months to pay. Partial payments, no return, ma'am, to this Quick Stop, 7955 Miramar Parkway, Miramar. Go back there, you'll be arrested. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed, and also partial payments, if I didn't say that, are accepted. Thank you. Okay, let's call Shane Mills, page 13. Hello. Only one of you today?
Yes, just me today.
Okay. Flying solo, huh?
Today, yes.
Okay. Shane Mills, please, page 13.
He's here, present judge at Maine.
Main jail. All right, detective or sergeant, announce your appearance for the record.
Stephen Kastner, Kastner, City of Hollywood Police Department. I'm a detective in the Vice Intelligence and Narcotics Unit.
All right, thank you very much. All right, Mr. Mills, you are charged with possession of weapon or ammo by a convicted Florida felon, 2 counts. And count 3 is distribute or deliver cocaine, $15,000 bond. Court does find probable cause. What say you, state?
Your Honor, I'm gonna be requesting a $15,000 bond on count 1, $5,000 bond on count 2. I'm gonna be requesting that the court keep the bond that Judge Usan set on his arrest warrant in place. I'm also gonna be asking on counts 1 and 2 that the court order that Mr. Mills be supervised by pretrial release with a GPS monitor, level 2. That the court impose all the special conditions that Judge Usan set on the arrest warrant. Noting Mr. Mills' criminal history, he is out right now on a pending possession of cocaine, possession of cannabis, possession of drug paraphernalia. Now, while the allegations in the arrest warrant predate his release on that matter, obviously the new charges of possession of firearm ammunition by convicted felon would be a violation of his release conditions. Additionally, 2018 misdemeanor possession of cannabis, drug paraphernalia, 2014 resisting without violence. In 2010, he was convicted of aggravated assault with a firearm, 1 count of battery, and 1 count of shooting at or throwing a deadly missile. He violated his probation and was sentenced to 53 months in Florida State Prison.
All right, what say you, defense?
One moment, judge, I just need a brief moment to speak with Mr. Mills.
Take your time. Stay away from anywhere?
Not for him. No, ma'am.
Okay, just double checking. And we need to discuss the passport. Mr. Romero,
Yes, judge.
the passport. Ask him
No
about
problem,
that.
thank you.
Thank
No
you.
problem. Thank you, Judge, for giving me that opportunity to speak with Mr. Mills. I was just speaking to him first as far as his resources, Judge. He's not gonna be able to quite afford what the state is suggesting. If my math is correct, that would be a total of $35,000 bond. What he does is basically he does, car detailing, landscaping, and he's an aspiring, music manager, Judge. Right now, I guess he's in the beginning of his career, so right now financially he gets about $500 per week. He's 28 years old. He's been here in South Florida for about 22 years. He has 2 children. Basically, he also helps his grandmother out. She's on a fixed income. She gets Social Security. So he's gonna be reaching out to his friends and family to help post his monetary bond. But as I said, his financial resources are limited. From what he advised me, he's looking forward to appearing in court and contest these allegations, Judge. I don't think he's a flight risk. He's been here his whole entire life in this community. Judge, what I'm going to be asking for is for a $5,000 bond on count 1, $2,500 bond on count 2. I'm going to be asking for a bond reduction on count 3 from $15,000 to $10,000. So, Judge, if my math is correct, that would be a total of $17,500 bond. Now, I do not object as far as Mr. Mills being supervised, but we would be asking for him to be supervised on standard pretrial release, make it a little bit more stringent where he basically has to call in rather than the standard as far as 1 time a week, have him call in basically every day and also have him report once a month. That will give him the opportunity to still be able to work and provide for his family, his grandmother, and his kids, Judge. So I believe that would be reasonable as far as what the defense is asking for, a $17,500 bond plus a heightened form of standard pretrial release. Now, I didn't talk to him as far as his passport. He was born here in the United States. Oh, you were. Oh, okay, I'm sorry. Okay, I got you.
All right,
misinterpreted what you
raise your
said.
right hand, Mr. Mills. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, go ahead, Mr.
Mr. Mills, are you a United States citizen?
Yes, sir.
And do you have a United States passport in your possession?
No, sir.
Do you have a United States passport card in your possession?
No, sir.
To your knowledge, have you ever had a United States passport or passport card?
I never had a United States passport. The passport that I had was a Jamaican one, expired, and I can't. Right now, I don't have the finances to get any passport or anything.
So you do have a Jamaican passport, is that correct?
No, I don't have that anymore. It was expired, and I lost the passport. So that's why I have to get my U.S. passport. But I haven't been able to pay for that.
Gotcha. Okay. So to your knowledge, as far as the Jamaican passport, you no longer have it in your possession because you lost it.
And I also have a police report that's stating that that's claiming the passport.
Any further inquiries, Judge?
Anything further, State?
I would ask, though, to, if I could be heard, Your Honor, nothing on the passport issue, though.
Okay. All right, anything else, Mr. Romero?
No, nothing else.
Your Honor, I have reason to believe that Mr. Mills is not being truthful in the information he's providing Mr. Romero as far as his financial resources. First, I would note, according to the probable cause affidavit for the arrest from yesterday, over $2,800 in cash was found in his wallet.
2839.
Yes. And additionally, Detective Kastner, if I may question him, has additional information.
Do you swear and/or affirm to tell the truth?
Yes.
All right, put your hand down. State your first and last name.
Stephen Kastner, City of Hollywood Police, Detective Vice Intelligence Narcotics.
Okay. And how long have you been employed with City of Hollywood?
January will be my 7th year.
Okay, great.
And Detective Kastner, have you had an opportunity before today to investigate Mr. Mills?
Yes.
Okay. And during your investigation of Mr. Mills, did you come across any evidence or any information that would cause you to believe that the representation about his financial resources to the court is not accurate?
Yes.
Could you please tell the court what information you came across?
Multiple pictures and videos on social media flaunting lots of cash.
And how recently are some of these videos or pictures taken or posted?
Late October
Of 2018?
of 2018, I'm sorry, yes.
And also, the vehicle he was operating yesterday when he was arrested was a 2007 BMW?
Yes.
I have nothing further, Judge.
All right, anything further, Mr. Romero?
Judge, like I said, he's aspiring in the music business. Sometimes to keep up that image, people post things on social media. From what the detective says, nothing what said is contrary to what we stated. As far as the vehicle, he doesn't own any vehicle, Judge. So I don't think anything which the detective offered today contradicts what I said, Judge.
Okay, Nebbia hearing, defendant not to possess or apply for a passport, passport card, full collateralization, GPS level 2. I know he's not allowed to, but I'm gonna say it anyway. No possession of any firearms, ammunition, or weapons. Any other special conditions state before I state what the bond is?
No, Your Honor, I believe that covers the special condition.
All right, 15,000 on one, 2,500 on two, 15,000 on three, for a total of 32,500. Thank you, sir. Good luck to you.
Thank you,
The
Your Honor.
only other request I'm gonna ask is because of his employment with car detailing, landscaping, aspiring music manager, Judge, he doesn't have a set schedule. So I'm gonna be asking the court to consider at this time an open schedule. He's gonna be on monitor. Pretrial's gonna know where he is at all times, Judge. So I think it's reasonable for me to ask for an open schedule, Judge.
Your Honor, based on the nature of the offense and that this involves drug dealing or,
With firearms, I'm gonna keep it at a GPS level 2. Let him go to his division judge. Thank you, sir. Good luck to you. Thank you.
Thank you, Your Honor.
Violent Albin.
North Broward judge, and it actually is Violet,
Okay, I was
and she
gonna
would
say-
like to resolve this matter this morning.
Okay. Court's not gonna resolve this charge today. Ma'am, you have prostitution, lewdness, offer to commit, engage, first act. Court does find probable cause, $300 bond. What's her prior history like, state?
Your Honor, I'm showing she was arrested. One moment, Judge. No, I got it right here. November 8th for misdemeanor domestic violence battery. She's out on a $500 bond on that.
All right, what say you, defense?
Ask you to release her on her own recognizance, Judge. She thinks her bond may be posted. Maybe we could check that.
Well, if it's not, I'll RO her. I don't have a problem, but. Ma'am, is your address 8031 Northwest 44th Court, 1? I can't hear you. Press the button in front of
You
you.
need to press the button in front of you, Violet.
It's in the middle. No, you just press it once.
Her bond is not posted.
Yes, that's my address.
All
That's
right.
the correct address.
All right, your bond hasn't posted.
I know that.
All right, ROR, thank you.
Thank you, Your Honor.
Have a good day.
You too.
Lisa Marie Martin.
North Broward.
Good morning, Ms. Martin. You have DUI, alcohol or drugs, first offense. Court does find probable cause, bond set at 500. Is your mailing address 1430 Sheridan Street,
Correct.
21G?
Correct.
All right, does she have a prior history, state?
She has a prior burglary of a dwelling and grand theft from 2013.
All right, on this charge, I'll ROR you, ma'am. Good luck to you. Show up for court.
Thank you so much, ma'am.
You're welcome. G. Quinta Williams, please.
He's approaching, Judge. He's
You
hearing
in
me.
jail?
Judge.
Okay, are you Gia Quinta Williams?
Yes.
All right, ma'am, you have neglected child with great bodily harm. Need to talk about bond. Court does find probable cause. What say you, state?
One moment, Your Honor. Your Honor, I'm going to be requesting a $10,000 bond.
What's her prior history?
I see no history, Your Honor.
Really sad circumstances. All right, what say you, defense?
Judge, I haven't had an opportunity to review the PC affidavit. From what my conversation with Ms. Williams, this was a tragic accident. I mean, she basically broke down crying when she was talking to me. Judge, my understanding is you probably saw, the date of incident happened a couple months ago. Judge, I know the detectives reached out to Ms. Williams from what she informed me. They were nice enough to go ahead and enroll her in grief counseling. She's been going to grief counseling. In attending grief counseling, it was suggested to her that she attend therapy. They set her up with a therapist, and she was actually supposed to start on Thursday with therapy. She's 27 years old, been here her whole entire life. She's a registered voter here in Broward County, as the state said. This is her first contact with criminal justice system as far as being arrested. She's working. She works at Kia of Cold Springs, where she's a porter there. She works on Monday, Tuesdays, Wednesdays, Fridays, and Saturdays from 7 a.m. to 2 p.m. and which she's making about $9.50 an hour. She is trying to also look for other work. She lives in North Lauderdale with her mother, and she lives there, I believe, with the father. Her brother, which would have been the father of the child. Right now, her mother is a caretaker. She's elderly. She doesn't have much income. Judge, there's really, as far as from her family point of view, they don't have much of financial resources to post a monetary bond. From my conversation with her, she has every intention of appearing before court and doing whatever is expected of her. I really do not have the slightest inclination as far as her being any sort of flight risk. I'm going to be asking Judge, and I know the charge, and it's it's a trap, but I'm going to be asking for pretrial release and whatever form or conditions this court deems appropriate. My understanding is, Judge, that there's no other children living in this household. I believe the detectives kind of told her that would be a good idea, and there was another child, and that I believe that child's no longer living there. But just as you said, it's a tragedy.
What kind of bond can she afford?
Let me talk to her. She doesn't know as far as her mother's financial resources, but she believes maybe her mom could come up with going through a bondsman about $150.
All right, I'm gonna do a $2,500 bond. Thank you.
Thank you, Judge.
Jennifer Priest.
Good morning.
Where are you, ma'am? North Broward?
Yes, ma'am.
Okay.
Or ROR from Ms. Priest, Judge.
All right, ma'am, you have driving while license is suspended, third or subsequent offense.
Your Honor, I would
Court
be-
does find probable cause. Go ahead,
Sorry.
state. No, that's okay.
I would be objecting to an outright ROR. I would note this is a crash case. While on the DWLS.
Ma'am, what's your mailing address?
7250 Northwest First Street, apartment 101 in Margate, Florida 33063.
All right, ma'am, I'm gonna ROR you, but no driving until you get a valid driver's license.
Yes, ma'am.
And they're also offering, I think you have to the 30th to, I don't know why your license is suspended, but you have until
Okay.
the 30th to sign up if you go to Broward Clerk. And it's
Okay.
December 5th, I believe. You gotta register beforehand and it does fill up. It could be full. And they do
Okay.
offer an incentive for you to, try to clear up your driver's license. They put you on a payment plan. You do have to come with some money, but if you go to the Broward
Okay.
Clerk and look for it, you'll see it, okay?
Okay, thank you.
All right. Very quick. Okay. Drifzer, 0, Sannels.
North Broward, Your Honor, Mr. Sandless would like to resolve this matter today.
Says this is an ad charge. What's count 1?
Aggravated assault, he's got a, I believe, a $10,000 bond. Pretrial GPS, I have no offer at this time, Your Honor.
Does the aggravated assault have anything to do with this?
No.
What's his bond? Where is he?
He's in North Broward, Judge.
North Broward, Deputy McCoy, Drifzer, 0, Sannels.
Good morning, Your Honor.
Good morning, sir. So you have an ad charge, petty theft, first degree, between $100 and $300, $100 bond. Court's gonna order no return, sir, to the
Yes,
Home
ma'am.
Depot where this allegedly occurred, which is at
Yes, ma'am.
1701 West Oakland Park Boulevard, Oakland Park, Florida, okay? What's
Okay,
his
ma'am,
bond
I
on the,
understand.
what's his bond on the aggravated battery?
10,000.
I was wondering if you could have that lowered, Your Honor, because I came in front of you for that same charge, and I'm having a very hard time getting somebody to bond me out, but they could do it if it's 5,000.
All right, have you spoken to your public defender about that?
Judge, he doesn't have one yet for
Yeah, I
some
didn't have
reason.
one.
In fact, the case is barely opened in Odyssey. So I'm gonna send someone out to see Mr. Sandless on count 1 so we can get appointed on his case. But right now, he doesn't have an attorney on that charge.
And, Your Honor, he just appeared before the court this past Monday, so it's not like the case has been outstanding for like a week or something, and that's why
Right.
things haven't necessarily been updated in Odyssey.
And I advise Mr. Sandless that the entry of a plea to this petty theft could have an adverse effect on his other charge. Not only could it add points to his score sheet, but since it is a crime of moral turpitude, if he took the stand in that case, he could be questioned about that as a prior conviction.
I don't plan on taking that to trial, Your Honor.
All right, well, don't tell everybody that. Keep one card in your pocket at least. But he does want to resolve it, and we've discussed it. It's up to him and it's up to the court. If you want to entertain a resolution, would invite you into the negotiations, Judge.
And Your Honor, is there any way you could have that bond lowered on my first charge?
All right, I'm not gonna deal with that, but you need to go speak to the public defender about filing a motion, okay? And going before your division judge and seeing if the division judge will reduce your bond on that charge. As far as this charge, what's his prior state?
Last year, he was convicted of domestic violence battery and an additional charge of violating a no contact order from another battery that
Yes.
he pled
Any
out.
other theft charges?
Yes, theft 2015, uttering a forged instrument, and grand theft 2011.
Okay, adjudication time served, 293.
All right, is that what you'd like to do, Mr. Sandless? It's an adjudication time served.
Yes, State.
Do you have any other questions about the consequences or ramifications of entering this plea, knowing that you also have that pending felony?
Raise your right hand before you answer. Do you swear and/or affirm to tell the truth?
Yes, Your Honor.
Put your hand down. Drifzer, Sannels, Sannels?
Yes, ma'am.
All right, go ahead, ask him how do you answer that question that your attorney asks?
Can he repeat it?
Okay, do you want to give up all your rights to a trial?
Yes, Your Honor.
You understand by taking this plea, it could increase the sentence in your pending
Yes, Your
felony
Honor.
case and all cases in the future. Do you understand that?
Yes, Your Honor.
How do you want to plead to petty theft, first degree, property between 100, 300, guilty? Not guilty?
contest.
Let me finish.
No contest.
Let me
Yes,
finish.
sorry, Your Honor.
Guilty, not guilty, no contest.
No contest, Your Honor.
All right, and you've had enough of time to speak to your attorney, Mr. Reedy?
Yes, Your Honor.
All right. Okay, adjudication time served, 293, 6 months to pay, partial payments, no return to the Home Depot. Thank you, sir. Good luck to you. Darrell Hughes, please. Darrell Hughes.
Approaching, Your Honor, North Broward. Hughes, come on.
Thank you, Deputy.
You're welcome, man. Well, he's moving a little slow today.
That's all right, no problem.
Stand on the X-Space TV, please.
All right, Mr. Hughes, you have resisting an officer obstructing without violence, $100 bond. trespass, structure, or conveyance. No bond required. Court does find probable cause. Court's gonna order no return, sir, to the Burger King at 40 North Federal Highway in Pompano Beach. If you go back there, you'll be arrested. Do you understand?
Please me understand that, yes, ma'am.
All right. So, I don't know if this case is appropriate for another division.
He had a trespass arrest. Ju- Your Honor, he was arrested in July for a trespass this year, and I don't know if it was you or another judge, it might have been over the weekend, transferred his case to Judge Lerner Wren. It ended up getting resolved in Judge Diaz, but initially it was transferred.
All right, so it didn't stay in Ren. All right, and he pled it out? Where was
Ultimately,
that no
yes.
return to state?
It was a different location.
Okay. So does he wanna resolve the case today, or does he want an ROR?
I didn't get a chance to talk to Mr. Hughes, Judge. Daryl, what would you like to do? Would you like to resolve it or get released on your own
I
recognizance?
prefer on this gentleman that you speak to him and make sure.
Sure.
Thank you. All right, Main Jail, call your next case, please. Main Jail,
Yes, Judge.
call your next case.
Let me go down. Mr. Justin McLeod, Judge, on page 4.
Okay,
Come on up, sir.
all right, Mr. McLeod, you
I
have,
heard you call me, Judge. I'll be back, I think. I don't know. Hold on.
Deputy at North Broward, can you mute the mic, please? Thank you. All right. So, sir, you have trespass, other structure, $500 bond. You are going before your division judge tomorrow, Judge Robert Diaz, at 9 a.m. Court finds probable cause for your arrest. A capias was issued. It says no show at arraignment, November 19th, 2018. What say you, state? What's your offer?
Withhold court costs, no return.
I'm sorry?
Withhold court costs, no return.
No return to where?
The old River House at 301 Southwest 3rd Avenue in Fort Lauderdale.
You hear that, sir?
He wishes to accept the state's offer. Yes, ma'am.
Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, Your Honor.
All right. Justin McLeod, McLeod.
Yes, ma'am.
Okay, you've had enough of time to speak to your attorney, Mr. Romero.
Yes.
Okay, he's the gentleman standing next to you, sir. Okay? All right. Want to give up all your rights to a trial? No? All right, do you
Do you
want
want to give up your rights to trial? Do you want to give up your rights to a trial, or do you want the trial?
I thought it was,
Mr. Romero, let me ask the question. Okay, Mr. McLeod, do you want to go to trial in this case and have the state prove the case, or do you want to resolve it today?
resolve it today, ma'am.
All right, then you want to give up all your rights to a trial and not have a trial in this case, which means you're giving up the right to have the state prove the case against you and so forth and so on. Do you understand?
Yes, ma'am.
All right. Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
All right, how do you want to plead to trespass property of a structure? Guilty, not guilty, no contest?
No contest?
All right, court's gonna accept your plea. Withhold court costs $293, 6 months to pay, partial payments accepted. No return, sir, to the old River House. Do you understand? If you go back there, you will be arrested. Court takes judicial notice of the time that he served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you. Call your next case, Mr. Romero.
Good luck, sir. The next gentleman, next page, would be Mr. Rennell Campbell, Judge.
Okay, Mr. Campbell, come on up. Can I have his driving record, please? Mr. Campbell, you have driving while license is suspended, first offense, $100 bond, and then count 2 is driving while license is suspended, no bond required. You failed to appear in court, or I don't know, there was a capias issued January 24th, 2018. Sir, where do you live? What's your address?
What's your
I stay by the Mobile.
You what?
I'm at the Mobile. I'm at the Mobile.
Hold on, mister. Okay. All right, can you mute the what's your name, sir?
Campbell, first name George. I'm at the food spot. I'm at the Mobile. I'm at the. Your Honor, what did you call? Sorry.
I called Renell Antoine
George
Campbell.
That's
No,
George
that's not
Campbell.
me. I'm sorry. His last name is the same.
Okay, that's fine, no problem. I was wondering where that was coming from. Okay. All right. Okay. Sorry about that, Mr. Romero.
No problem, Judge.
All right, so we have driving while licenses suspended. And then we have a KPS issued January 24th, 2018. Sir, what's your mailing address?
It's 1340 Northwest 196.
1 hour, 2 hours. 1
Miami?
Yes, ma'am.
That's all I need.
He has a failure to appear 2/27/2018 in Broward. He has DL expired.
2018.
Yep. He has driving while licenses. Sir, I'm just telling you what it's saying. I'm telling you when you failed to appear. He has a failure to pay a toll, failure to keep in proper lane, driving while license is suspended, 2011, and a driving while license is suspended, 2009. All right, what say you, defense? $600 bond total.
Judge, in speaking with Mr. Campbell, he wishes to resolve both matters today.
The offer on count 2 would be a withhold court cost. On count 1, adjudication, time served, court cost.
Raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
All right, your name is Renell Campbell.
Yes, ma'am.
All right, sir, put your hand down. You want to resolve your case today?
Yes, ma'am.
Or both cases today?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
You understand that if you get if you get 3 driving while licenses suspended within a 5-year period, let me finish. Because I ask you the question and you have to answer when we're recording, and you have to make sure that it's on the record, okay?
Okay.
All right. So, do you understand that if you get 3 driving while licenses suspended within a 5-year period, sir, Driver's License Bureau is going to suspend your license as a habitual traffic offender. If you're caught driving during that time, it then becomes a felony. Do you understand that?
Yes.
All right. Anybody forcing you to do this?
No.
Are you under the influence of alcohol, drugs, or medication?
No.
How do you want to plead? Guilty, not guilty, no contest to driving while licenses?
Contest.
How do you want to plead, sir, to driving while
No
license?
contest.
Sir, you keep blurting out stuff. You don't let me finish. Let me
I thought
finish.
you already said it.
No, let me finish the question, okay? How do you want to plead to driving while license is suspended, first offense, and 2, driving while license is suspended, canceled, or revoked? Guilty, not guilty, no contest.
No contest.
All right, court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Adjudication time served on count 1 and in case number 17-50073 TC 30A. Court's going to withhold and court costs. Count 1, I'm also going to do court costs. So $293 in court costs on each count, 6 months to pay, partial payments accepted. Court takes judicial notice of the time that he served in the Broward County Jail in the 2017 case. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you.
We could return to Mr. Hughes if the court's inclined.
Sure. North Broward, Darrell Hughes, please. North Broward, can we see Mr. Darrell Shane Hughes?
Mr.
The one that was just the gentleman that was just talking to Mr. Reedy on the phone, Darrell Hughes.
You like to see Mr. Hughes? Yes. Mr.
Thank
Hughes.
you.
Mr. Hughes, the judge would like to see you again. Approach, Your Honor.
Thank you, sir. Okay, Mr. Hughes. So what are we doing with this, Mr. Reedy? You've spoken to
Mr. Hughes has indicated to me that he would like to give up his right to a trial and to a plea of no contest and accept the offer, which I believe was a time-served offer.
Okay, as an officer of the court, are you telling me you didn't have any concerns?
Some, but I think he understands what's happening.
Okay, so you feel comfortable of him entering into a plea?
I do.
Okay?
There
Raise
was,
your,
just for the record, there was no offer made at this point, Your Honor.
Well, there is no offer made yet at this point. We're inviting the court into negotiations.
I'm not saying there isn't an offer, I just have to look.
see 2020 Scott Street, does he live there now? Does he want to go to the receiving center or somewhere else?
He did not mention any desire to do so, Judge.
Sir, do you have a place to live?
No, ma'am, I do not have a place to live. I am homeless. 2020 is my mailing address. 2020 Scott Street is my mailing
You
address.
want to just ask him about it briefly?
Sure. There's a place called the Central Receiving Center. They could pick you up at 9 o'clock tonight and take you there. It's completely voluntary.
Oh, thank you. I
No,
do
no,
not
no,
want to go
he was
there.
there before. He was
Excuse
there
me,
before.
excuse me. The receiving center, I'm sorry, what is that?
It's on 441, just
Okay,
south of
I'm gonna
Commercial
cut you
Boulevard.
off.
I think
He
I
was there
sent
before.
there, last time,
And he
and
was
it was sold out.
trespassed.
Waited to be there for 23 hours or so to get the help I needed. And I got kicked out of there too, yeah.
This,
I
Your
don't know
Honor,
if I was arrested.
Hold on, Daryl.
this would have to be an open plea. I just checked, the last trespassing, which was at Henderson, also was transferred to Judge Lerner, and he ended up pleading it there. Now, while I understand there wasn't, and I'm sure there was reasons why those cases ended up getting resolved and there wasn't any further assistance, I do have some concerns now that the prior two cases were transferred there.
All right, this is what I'm gonna do. I'm not gonna resolve this today. I'm gonna order no return to the Burger King where you were arrested, sir. I'm gonna put you on standard pretrial supervision. I'm not gonna require a bond. Your address, you have to, check with the 2020 Scott Street. If not, you can check with pretrial services. I'm
I
gonna,
heard that one too.
pretrial services, sir, is what I'm putting you on. Okay? Should we refer this to Ren again or no?
I don't have an objection to that. I mean, we're, you know.
That's what I'm gonna do. I'm gonna refer this to Judge Wren. And I'll set his bond at $25.
Remember that?
Okay? Good luck to you, sir. You'll see Judge Wren tomorrow.
I'm not leaving right now.
Necessary? Keith Necessary.
He's here present, Judge. My understanding is he has private counsel. Mr. Tom Morrison, I believe my colleague went ahead and contacted him.
Morrison?
No, Morse.
Yes, Judge, he's available by phone if you want to give him a call right now.
Sure.
8316172.
83 what?
No, Judge, it's 954
Yeah, I was gonna say.
522 3205. All right, have Sean give me a call so we can figure out what it is he wants to do. His name is John Henry Thompson.
Your mic is on.
Hello?
Yes, hi, Tom Morris. This is Judge Malika, Magistrate Court in Broward. You're being recorded. You're on speakerphone.
Hey, Judge, how are you?
Good, how are you? Nice to hear from you again.
I'm fine.
All right, so I have your client Keith Necessary in front of me. He has some ad charges. Do you want to appear by phone?
That's fine, Judge, I can skip my phone.
Okay, good. All right, so, Mr. Necessary, you are charged with an ad charge, burglary, unoccupied dwelling, unarmed. We need to talk about bond. Count four is false owner info for pawn items less than $500. Court does find probable cause. Bond on count 4 is $1,000. State, what is it that you're requesting on count 1?
Your Honor,
Count 3.
I'm requesting a $5,000 bond. He's being held on the top charge, charge 1 for armed burglary.
Okay, is that a no bond hold?
Yes,
Okay,
and just would be asking for
no victim
no
contact?
victim contact, no return to this residence.
Any objection?
No.
All right, so $5,000 bond on the burglary, false owner info 1,000, no victim contact, sir, direct or indirect with CH, and no return to 2420 Northeast 2nd Avenue in Pompano Beach. Anything else from anybody?
No, Judge.
No, thank you, Judge. Thanks for the call.
You're welcome, thank you, bye-bye. Thank you, sir. Cheryl Smith Martinez. Or Charlie, I'm sorry.
Mr. Charlie Smith is here, present, Judge?
All right, Mr. Smith Martinez, you have possession of burglary tools with intent to use, $1,000. 2 is loitering or prowling, no bond required. 3, 4 are court orders for juvenile, no bond holds. Count 5 is an out-of-county hold for a misdemeanor, that's no bond. Let's see. It's at a Brevard, failure to appear for a traffic arraignment, reference no DL or operating a motor vehicle without a valid driver's license. 6, 7, and 8 are no bond holds. They're actually, all the no bond holds are not for magistrate. The court does find probable cause. What say you, state?
In light of the juvenile holds, I'm asking that the bond on count 1 be kept in place, Judge.
Any no return or no victim contact?
I would be asking for, I don't have a request of no victim contact. I would be requesting no return to 611 South State Road 7 in Margate.
Okay, anything further, defense?
Judge, considering the no bond hold, nothing to add at this time.
All right, sir, no return to the 611 South State Road 7, Margate, Florida. Do you understand? That includes a parking lot. If it's a development, sir, it's a, that means the whole entire development. Do you understand? Thank you, good luck to you. Anthony Matranga,
No problem.
thank you.
And I provided the court and defense counsel with paperwork, an additional report on this case.
Oh, yes, I have it, thank you.
You're welcome.
All right, so, Mr. Matranga, you have missile into a dwelling, vehicle, building, or aircraft. Court does find probable cause. What say you, state?
Your Honor, I'm going to be, first, I'm If I could just check to see if there's any criminal history, Your Honor.
Sure.
Thank you. Okay. Out of the state of Texas in 2003, he was convicted on federal charge of bank robbery, sentenced to 130 months in federal prison to be followed by 3 years supervised release.
That was when?
That was in '03.
Okay.
In 2013, he was found to be in violation of his probation from that case and sentenced to an additional year and a day in federal prison. '99, unarmed robbery out of the state of Massachusetts, sentenced to 2 years and a day in state prison. Your Honor, I'm going to be requesting a $7,500 bond, no victim contact, pretrial release with a GPS monitor. It's not just based on his priors, but also the facts in this case, and that's why I provided the court with the additional report, because it goes into a little more detail that this doesn't appear to be a spur-of-the-moment thing, that he had threatened them previously to do exactly what he did, throwing a large rock through their window while they were home. The rock almost striking them, and put them in fear for their safety, Your Honor.
All right, sir, we have a public defender here today who's representing you. What say you, Mr. Reedy?
Judge, I think when this works itself out, we'll find that Mr. Mantragna was prescribed some medication that he had a bad reaction to. And I notice in the additional report provided by the state, it says they've been having issues with him lately. Doesn't say they always had issues with him. And from what I understand, he'd been living in this location for 3.5 years.
Is that where he lives now?
I'm sorry? Well, that's where he would live. He understands he can't have...
What's his address?
What's your address, sir?
4644 Poinciana. Your Honor, I was arrested at my doctor's office. I was going to go get help for a 5-day detox because I had a bad reaction on the medication that they gave me. And if you can look at the address.
Sir,
Right. Hang on, Mr. Mantegra.
Yeah.
Sir,
Where would you be living if you were released, sir?
Oh, at a friend's house.
What is the address there?
Oh, what's the address? 138.
Is it 131 Northeast 38th Street, number 7, Oakland Park?
Yes.
Okay.
Yes. Yep.
Do you have any belongings in the Poinciana Street address?
No, I already got it all. It's all in storage.
Okay. All right. So what say you, Mr. Reedy?
Well, unfortunately, Judge, he's not able to work. He has a disability, which I alluded to a few moments ago, that prevents him from working or saving up any kind of money. He does have a friend I can contact who he believes would be able to post some bond. Mr. Mantegra is expecting a disability check this Friday that would go to that friend. It's in the amount of $500, and Mr. Mantegra indicated to me that his friend might also be able to come up with another $500. But I think that's pretty much the extent of the financial ability of Mr. Mantegra to post bond, Your Honor. He has been a resident of Florida 4 years. He's been working at the same job, at the same cable company for the last 3.5 years.
Where does he work and what does he do?
He lays optic fiber cable and works. What's the name of the company again, Mr. Mantegra?
Access Cable.
Access Cable.
And he pays me on the table because I'm on disability.
But don't, let's,
Being honest.
well, sometimes silence is the best policy, Mr. Mantegra. I got that PC sheet for you in here, Mike.
All right. No victim contact, direct or indirect, with MM and TT. No return to 4644 Poinciana Street, Lauderdale by the Sea. And I want you to maintain 500 feet from the victim and that residence all the time. That includes any parking lots, sidewalks, etc. Okay?
Yeah.
Court's gonna do a $2,500 bond. Thank you, sir. No return to the 4644.
And I'll call your friend for you, Anthony.
Thank you.
Who do you have, sir? Take your time, but who do you have?
Ernst Tinor, T-I-N-O-R.
I'm sorry?
Ernst, E-R-N-S-T,
Do you know
Tinor,
what- Do you know what
T-I-N-O-R.
page that is? I'll just pull it up the side.
Thank you so much.
Do you know what page?
That I didn't.
Oh, I got it. Ernst Tenor?
Yes, ma'am.
Okay.
Few moments. Thank you, Judge.
Take your time. We have a lot to go through. All right, Aaron McFadden, please.
Page 13.
Oh, it is? Okay.
McFadden, Judge, I've been informed there's a medical
Okay, so Aaron McFadden is a medical reset. Stephen Louis Gutierrez, please.
Mr. Gutierrez is here present, Judge, at Maine. He's coming up.
Okay, Mr. Gutierrez, you have aggravated stalking, follow, harass, cyber stalk. Court does find probable cause. There was a warrant issued with a $25,000 bond. What say you, defense?
Judge, I'm gonna be asking the court to consider a bond reduction from $25,000 to $2,000, along with pretrial release. He's 39 years old, been here his whole entire life. He's self-employed, he does landscaping, he's been doing that for about 2 years. He gets on an average about $300 per week. He lives in Davie locally. He rents out a trailer that he's been living in for about 1 year and a half, in which his monthly payment is about $700. My understanding, he's gonna contact his father, and his father is on a fixed income on Social Security. So Judge, that's why he believes hopefully his father can come up with $200, and that's why we're requesting $2,000 along with pretrial release, Judge.
Victim's initials? I have the mother's.
No, it's, RG. It's in the first paragraph, about 3 sentences from the bottom, 3 lines from the bottom.
I see. Okay, let me just highlight that. Thank you.
You're welcome.
Okay, court's gonna do no victim contact, direct or indirect, with the alleged victim in this case, with the initials RG and RG's mother. I want you to maintain one mile minimum. GPS level 2. What time does your client work?
Usually it's 8 o'clock to 4, depends how long my route takes. He has set clients, Judge, and basically it depends on the schedule. Sometimes it's longer. Right. It all depends. Shorter, longer.
Okay, GPS level 2. I'm gonna do a curfew from,
If I can give you additional information, Judge, I don't think that's gonna be necessary. My understanding is, in speaking with Mr. Gutierrez, he was here before on an incident in which you went ahead and ordered no sort of contact, which basically this offense that he's here predates it. So he was adhering to a court order as far as no sort of contact or anything like that. So obviously now he's still gonna be abiding by the court order, no contact. Judge, I would be then asking if the court is set on having him placed on an enhanced form of supervision with level 2, then I would request an open schedule and no curfew. I mean, he's adhering to a court order and he hasn't had any sort of contact, so his actions speak louder than words. He's actually complying with it.
all right, let me ask you a question. When was he last here before me?
On the last time I saw him? Yeah, the 24th, man.
Of what month?
Of October, I believe it was. October, yes.
Okay, first off, Your Honor, one, we don't know if he's been around, based on these allegations, we don't know if he's gone around this person's home or not. He wasn't on a GPS then. As you can see in these allegations, he stealthily keeps going to this, his estranged wife's home and stalks her.
What's the other case?
It's a criminal mischief, Your Honor. The court was clearly not aware of all these other allegations. He was ROR'd, but it was just, the only allegation in that case was the first criminal mischief mentioned in the arrest warrant affidavit. It's 1810391 MM10A. But clearly, there's a lot more aggravating allegations before the court today. I'll wait till.
And I don't dispute that, Judge, but it
Hector.
predates it, and he's following the court's order as far as no sort of contact. So I understand
Hector,
as far as.
only one person talking at a time, he's not finished, but why don't you both
Oh, he's
wait?
not finished?
That's what I was gonna say, Your Honor. I'll wait for you to read the
Hold on, you
report.
can't see me, but I'm trying to pull up this other case. I wanna see it, because these allegations are serious.
Of course.
What's the other case number,
10391 MM10A.
All right, this is in front of Judge Cal Evans. All right, I have to tell you, Mr. Ramirez. Last time it says he punctured tires of a neighbor and the neighbor had him on camera. And this time it's saying he was slashing tires of his, I don't know if it's his ex-wife or his future ex-wife. I believe they're going through a divorce. So I'll let you finish, Mr. Linder, and then I'll let Mr. Romero respond.
Sure. Your Honor, clearly, first, based on these allegations, I do believe that the bond that, is it Judge Uson?
Yes.
The Judge Uson said is appropriate. GPS level 2 is completely appropriate, Your Honor. With an open schedule, especially with these allegations, I think it is imperative that pretrial,
I'm gonna do a GPS level 2.
okay.
So go ahead.
Your Honor,
Judge, then there's no sense of if you're gonna do what the state says, there's no sense in me giving you any additional
Well,
information.
based on, go ahead, I'm open.
well, I would, Your Honor, because there's still the bond matter.
Okay,
Your Honor, first off, as you can see, he just continues, and there's strong evidence, to terrorize this woman and harass her. He has a history of domestic violence arrests. In 2011, he was arrested for 2 counts of domestic violence battery against a different alleged victim. Those were dropped. In 2008, he was arrested for domestic violence battery. That was dropped. In 2007, he was convicted of tampering with a witness or victim and domestic violence battery. He violated probation, was sentenced to 17 and a half months state prison. That was against a different alleged victim than the victim in this case and the other domestic violence batteries. In 2002, he was arrested for aggravated battery, child abuse, and simple battery. Those charges were dropped. In 1998, he had a burglary of a dwelling, grand theft, and possession of burglary tools.
go ahead, Mr. Romero.
Judge, from what Mr. Gutierrez already advised me, he was here on October 24th. The same information which the state is basically reciting at this time, the court heard before. And he was released on that case. He was given conditions to adhere to. He's been adhering to those conditions. I'm not arguing as far as basically a monitor, Judge. I'm asking because he's adhering to the conditions of the court. He's going to court. He went to court this past Monday So that's evidence of him. He's not going to flee. The whole purpose of this bond is for him to assure public safety and his appearance in court. He is going to court, Judge. He hasn't had any sort of contact with this person since these allegations. So, Judge, I'm asking simply for an open schedule.
And Your Honor, part of the reason why I believe it's so necessary to know where he is, based on a schedule, is some of these allegations, Your Honor, didn't even occur at her home. It occurred at other family members' home. And the only way he could possibly have known she was going there if he's following her. And if he's on an open schedule and he's following her on the open road, the court would have no idea. The pretrial would have no idea that he's violating the court's order.
Anything further?
Judge, all I know is the state is arguing a lot of what ifs, and I'm giving you concrete evidence as far as what happened. As far as he adhering to a court order, going to court. So I'm asking for an open schedule, Judge.
No victim contact, direct or indirect, with RG and RG's mother. I want him to maintain 1 mile at all times. GPS level 2. I'm going to do a curfew from 7 p.m. to 6 a.m. daily. I am going to keep the $25,000 bond in place. The court has a concern with the nature and circumstances of the offense charged, the weight of the evidence against the defendant, and the defendant's past and present conduct. Thank you, sir. Good luck to you. Hi.
If the court can recall Ernst Tenor, Mike Gottlieb on his behalf.
Sure. How are you, Mr. Gottlieb?
I'm well, Judge. How are you?
Fine, thanks. Nice to see you.
Nice to be here, Judge. Nice to see you.
Okay. All right. So, Mr. Tenor, can you see your attorney, sir? Can you see your attorney?
Yes.
Okay, good. All right, so you waive formal reading?
I do, Judge. I've reviewed the PC, and based on what I've reviewed, I do believe there's probable cause.
Okay. All right, so the court does find probable cause. The court's going to order no victim contact, direct or indirect, with the alleged victim in this case, whose initials are MD. What say you, State?
Your Honor, on counts 1 and 2, they are punishable by life offenses. I'm going to be requesting that the court make a finding of proof evident or presumption great for first appearance purposes only, seeking a no bond hold on counts 1 and 2. On count 3, I don't know if the court wants me to make a bond recommendation now or if you want to.
Sure, might as well.
Okay, on count 3, I'd be requesting a $50,000 bond. Your Honor, the only other release conditions I'd be requesting is no contact with minors. And since it appears that Mr. Tenor knows the family of the alleged victim, no contact with any of the alleged victim's family members or immediate family.
Okay, Mr. Gottlieb?
Judge, as I said before, I agree that there's PC, but proof evident presumption great. It's a delayed report. There's no scientific evidence. There's no witnesses that are listed in the probable cause affidavit. There's nothing to suggest that this is a virtual certainty that the state will get a conviction should the case proceed to trial. There is a vague statement in the police report that he made some kind of inculpatory statements and that the acts were consensual. Other than that, I don't see it as a proof evident presumption great type of case. I would ask the court to exercise discretion and set a bond. I would also tell the court that Mr. Tenor came to hire me about 2 weeks ago when he caught wind of the investigation. He's been very attentive to me, to my office. He asked me if he could travel with permission. I told him he could because we didn't know of any case, and I've been diligently trying to track down whomever had the case. It was quite a surprise to me today that he was arrested yesterday because, and I guess oftentimes when cases are sealed such as this, they're just very hard to find. We weren't able to find it. He's been in Broward County, according to the police report, for 25 years at the same address. I don't believe him to be a flight risk based on the fact that he's retained an attorney. He's lived here for a long period of time. And again, it's a delayed allegation. I think $50,000 total on the case would perhaps be appropriate, but for just one count is extremely excessive given what we see as the facts of the case. Obviously, a monitor, I wouldn't have any objection to.
Well, Your Honor, first
And
I'm sorry.
Go ahead, I'm not lessening it, but this is a long time ago.
Well, Your Honor, one, as the court's aware, it's not unusual for young children to not immediately report these things. Two, I would note, based on the allegations, he threatened her. And she said that's the reason why she didn't immediately report it, because she was in fear.
Okay?
Your Honor, I would also note, I would ask the court to rely upon the specificity that the alleged victim provided in her statements, which I think
She
lends
did
credibility.
provide very specific. She
And-
was very specific.
And lastly, under the direction of law enforcement, the victim's mother made controlled phone calls with the defendant where he made inculpatory statements, admissions to improper conduct, and accused the victim, who was 8 or 9 years old at the time, of pursuing him.
Yeah. All right, anything further on the proof evident presumption great or bond?
No, just that those alleged admissions are, for a very detailed probable cause affidavit, the admissions are, there's no detail to them, just that he allegedly made these admissions. So I really can't speak to, I don't understand why the police report would be so detailed as to things that the victim allegedly said, but scant as to what the defendant allegedly said. I don't think proof evident presumption is great based on what we have before us today.
All right, I am gonna find proof evident presumption great. These are some very serious allegations, they are very specific, and based on the totality of the circumstances, I'm gonna find probable cause, and I'm gonna find the proof of guilt to be evident or the presumption great as to counts 1 or 2. Therefore, sir, you're gonna be held without no bond on those counts. This order is without prejudice on counts 1 and 2 for you to file a motion to set bond with your assigned division judge, request a hearing under State v. Arthur. That doesn't mean, sir, that your attorney didn't do a good job today. It just means that you're gonna go before your division judge, and your attorney's gonna set a motion. He's very well liked and respected in the community, and he'll file a motion before your division judge to set a bond potentially on counts 1 and 2. Count 3, I am gonna set the bond at $10,000. Order no victim contact, direct or indirect, with MD and MD's immediate family members. I am gonna do a GPS level 2, and I am gonna do, anything else, sir?
I requested no contact with minors, Your Honor.
And no contact with any minors. Thank you, Mr. Gottlieb.
Thank you, Judge.
Nice
Is the
seeing
court
you.
able to tell me who the presiding judge will be?
I think they're gonna tell us after they,
I think I can get that right now.
Okay, I'll speak to the state. Thanks, Judge.
yeah,
Appreciate
you're
that.
welcome. Have a good day. Hello. All right, let's go off. Elijah Velez.
Medical reset, Judge.
Wendell Rodney.
He's here present, Judge of Maine, he's approaching.
All right, Mr. Rodney, you have a host of charges here. Can you have the deputy at the main jail lower it, because I can hear my voice really echoing,
Lower what?
the volume.
They cannot, they don't have access to what they're saying to the control.
All right, hold on a moment. All right, so Mr. Rodney, welcome back. You have burglary, unoccupied conveyance, unarmed, counts 1 and 2. Count 5, count 7, 8, 9, 13, 14, 15, and 19. You have grand theft between $300 and $5,000, bond set at $1,000 each on counts 3 and 4, 6, 10, 11, 12, 16, 17, 18, and 19. Court does find probable cause.
I have an issue with that, Judge.
Sure, tell me what it is.
Well, there's an awful lot of charges, 20 of them, in fact, that Mr. Rodney is facing here. And I'm reviewing the probable cause affidavit. It appears to me as though with one of the burglaries of the unoccupied conveyance, a fingerprint was found and later determined by the Broward Sheriff's Office to belong to Mr. Rodney. The rest of the evidence against him in reference to the other burglaries seems to be very circumstantial. It does say when Mr. Rodney was arrested, he was in the company of persons known to have a history of stealing airbags, but that doesn't mean that he was stealing airbags or that he broke into these other vehicles. The vehicles that were occupied had a number of airbags inside the vehicle. Doesn't
You found it?
So it appears, Judge, as, and I would argue there is probable cause to establish.
Go ahead.
Did you want to say something?
No, I'm just telling the judge,
But no,
they
they
couldn't
wouldn't.
hear.
Okay.
Mic wasn't on.
That's because they're playing with the, Pat's playing with the audio, but go ahead.
Okay. So in conclusion, Judge, I would say I do believe there is probable cause for one count of burglary of an unoccupied conveyance based on the fingerprint evidence against Mr. Rodney. And I would even say that there is probable cause to support one count of grand theft, although I don't know in here there's any reference to the actual value of the airbag that he is supposedly accused of stealing. And I would argue that there is no probable cause to support the other charges against Mr. Rodney here this morning.
State?
Well, Your Honor, Mr. Reedy's right, it is circumstantial evidence, but as the court's aware, the law supports that circumstantial evidence can still support a finding of probable cause. I would note, which Mr. Reedy left out, every single vehicle that was broken into in the same exact fashion. That being, that each vehicle had their car door locks forcefully removed. Every single vehicle within a 1.2 mile radius. Mr. Reedy mentions the airbags, but what he leaves out is every single airbag they found belonged to one moment, Honda and Acuras, which was the make of all the vehicles that were broken into. Your Honor, based on the totality of this evidence, albeit circumstantial, I still believe there is probable cause.
And just by a brief rebuttal, Judge, yes, these vehicles were broken into, but it is not established by probable cause in this probable cause affidavit who broke into these vehicles. And that's an essential element of any type of case against the defendant. Was the crime committed? And is the accused the person who committed the crime? And we do not have any probable cause to establish here that Mr. Rodney is the one who committed the crime.
The circumstantial evidence does point to him. There's
I'm gonna
fingerprint.
find probable cause. On its face, it appears that Mr. Rodney broke into all these cars, so. What say you with regard to bonds?
Your Honor, I'm going to be requesting a $5,000 bond on each of the burglaries. I am concerned just based on the sheer number of burglaries before the court and the safety of property in the community. I would also note, Your Honor, Mr. Rodney's 20 years old. In 2016, as a juvenile, he was placed on probation on a related felony offense. It looks like he was taken off probation only because he aged out at 19 years old.
Okay. Go ahead, Mr. Romero.
Judge, I believe what Mr. Lender is referring to is an offense that happened when he was a juvenile, when he was a child, and I believe it was a grand theft. I believe that's what he's referring to as far as related offense. He is 20 years old. He's been living in South Florida his whole entire life. He works for a company called Out of Time. He's a handyman. He's been there for about a month and a half, and he gets paid about, on an average daily, he gets about $50 per day. So the bonds amount, which the state is suggesting, is something that basically he cannot afford. So in other words, he's going to be held for all practical matters here in custody because he's not financially going to be able to afford that bond. Judge, I'm going to ask you at this time to take into consideration my colleague's argument as far as for mitigation purposes, the weakness of the state's case. I would ask, Judge, I know the court made a ruling, you found probable cause. I'd ask for a $500 bond on each and every count. There's 20 counts. If my math is correct, that would be a total of $10,000. This is his first felony offense as an adult. I believe that's reasonable, taking into account the mitigating circumstances that we are asking for at this time. He does live locally. He lives locally in Hollywood with his cousin. He's been staying at the same premises for about 7 months now. He's going to be contacting his friends, his family to help post his monetary bond to try and come up with that amount of money. From what he informed me, his cousin is a DJ. So it depends on as far as what kind of jobs he lines up. But right now, I believe what we're asking for is reasonable under the circumstances, Judge.
Your Honor, I apologize. I wasn't going to bring it up, but since it was brought up, his juvenile prior wasn't a grand theft. It was a grand theft auto, which I think is more relevant. Well, it's more relevant to these allegations than just a simple grand theft, taking over $300 worth of property at Target, for example.
All right, count one. All the burglaries, unoccupied conveyance, 2,000. All the grand thefts, $500. GPS level 2, curfew 7 p.m. to 6 a.m. Thank you, sir. Good luck to you.
Your Honor, I apologize. Did the court order no victim
Oh,
contact?
no victim contact, direct or indirect, I'm sorry, thank you. With MENS, CR, RC, JK, GUF. I have them all right here. JG, JSC, AVA, GG, and JR. Thank you.
And Your Honor, I'm sorry. I would also.
A lot of them are tabbed.
I would also request, Your Honor, no return to any of the listed incident locations, and I'm just referring to on the first and second page of the probable cause affidavit under the 5 BSO case numbers, there's locations listed.
Okay? Would you like to,
You want me to state them?
well, Ms. Patrice is gonna need them.
Yeah, I'll provide them. I don't know if you wanted me to state them on the record as well.
Yeah, sure.
Okay, it's 2821 South Oakland Forest, Oakland Forest Drive in Oakland Park. 3090 Northwest 30th Place in Oakland Park. Actually, you know what, Your Honor, what might be easier is if, I would just be requesting no return to these communities, because and that would be Forest Park, Cambridge Park, Lakeview, and the Lakes.
You got that, Ms. Patrice? I think you have to tell her.
I
I gave her my package, she has it. Show her where it is, okay. Okay. All right, sir, no return to any of those communities, thank you. John Thompson, please.
Judge, he's approaching, he declined the services of public defender.
Okay. All right, Mr. Thompson, you're
John
under,
Conchia is his private attorney.
I spoke with Mr. Cassia earlier. Mr. Cassia does not represent Mr. Thompson.
all right, so Mr. Thompson, do you want me to appoint the public defender? You have to fill out an affidavit?
Yes, I want to appoint him.
Okay, thank you. All right, so we'll give you a moment to talk to him. Who's the next person you have at Broward, North Broward?
I'm ready to proceed, Judge.
So you did speak to him?
I did speak to him, and then he informed us that he had private counsel, so
Okay,
I had the information already.
thank you. Mr. Thompson, you have used, display, et cetera, firearm during a felony. There's no bond, we need to talk about bond. Count 2 is possession with intent to sell, manufacture, or deliver cocaine within 1,000 feet of a specified area, $7,500 bond. Trafficking in heroin between 4 grams and 14, $75,000 bond. Possession with intent to sell, manufacture, or deliver cannabis with $1,000 within 1,000 feet of a school, child care, or park, $5,000 bond. Count 5, possess with intent to sell, manufacture, or deliver MDMA, also known as ecstasy, $2,500 bond. Count 6 is possession of buprenorphine, $1,000 bond. Count 7 is possession with intent to sell, manufacture, or deliver oxycodone within 1,000 feet of a specified area, $7,500 bond. And count 8 is possession with intent to sell, manufacture, or deliver morphine within 1,000 feet of a specified area. We also have counts 9 and 10, possession with intent to sell, manufacture, or deliver alprazolam within 1,000 feet of a school, child care, or park, $5,000 bond. And count 10 is obstructing the police, serving or executing a search warrant, $100 bond. Court does find probable cause. What say you,
I have an
State-
issue with probable cause, Judge.
sure, tell me the count.
Count 1.
Sure.
There's no allegation here that I can see in the probable cause affidavit that at any time Mr. Thompson used or displayed a firearm during the commission of a felony. It looks like the firearm was found at the bottom of a backpack.
Yes. State?
Your Honor, the
You
case,
agree?
no, because the case law covers use is also to cover possession. Clearly, he was seen fleeing from this location. And why, Your Honor, I would argue it does apply is the drugs were found in the backpack, I believe.
With the gun.
Exactly. If they weren't found there, then I would agree. But it could be
All right,
argued.
so I am gonna find probable cause.
Over defense objection. As to count 2,
Sure.
possession of cocaine with intent to deliver. If I'm reading this report correctly, 2 bags of crack cocaine and some powder cocaine were located in a sock that was on Mr. Thompson's possession. Without more, specifically as to the weight of the cocaine, how much cocaine was in these 2 bags, how much powder cocaine are we talking about here? There is only probable cause to support an allegation of possession of cocaine, not possession with intent to sell.
Your Honor, I would argue, based on the totality of the circumstances, the amount of different drugs that were found, that they found $891 cash on his person after he stated he doesn't have a job. Based on the totality of the circumstances, I think the court can determine that essentially this is a drug house.
I have over $100 in my wallet right now. I'm not selling drugs.
But he didn't have
The fact
100.
that,
He had almost
and I'll
900.
say something else, since I did not interrupt you, Mr. Linder, that we don't know how much drugs are involved here. This probable cause affidavit, and it's very poorly written, states that that 9 individually packaged bags of cannabis, oxycodone, and alprazolam were found in this sock that Mr. Thompson's accused of having thrown. We don't know if it's 1 bag of cannabis and 7 bags of oxycodone and a bag of alprazolam.
It
We
says
don't know if
9
it's
individually. This is what
doesn't
it
matter
said.
because you could have 1 bag of each of these drugs the way this is written.
Let me read this to you. It says inside of a sock was more heroin, 2 bags of crack cocaine, powder cocaine, 9 individually packaged bags of cannabis, oxycodone, and alprazolam. He had $891 on him, and he was in 1,000 feet of Ovietta McKeithen Park.
Right, so exactly, Judge. This does not tell us how many bags of cannabis there were. It does not tell us how many bags of oxycodone there were.
It says 9 bags of cannabis.
That's not what it says.
Yes, it does, right here.
It says 9 individually wrapped packaged bags of cannabis, oxycodone, and alprazolam. We don't know how much alprazolam was in, how many bags of alprazolam there was, or how much alprazolam was in that bag. We don't know how much oxycodone is involved, or how much oxycodone was in that bag. We don't know how many bags of cannabis are involved, or how much cannabis was in that bag. And while I do agree that there can be probable cause to establish possession of these drugs, there is no probable cause, based on this language, to find probable cause to conclude that this was possession with intent to distribute any of these drugs.
All right, based on the totality of the circumstances, I agree with the state. I am gonna find probable cause on all counts. Any other
Well,
objections?
that's very much over our objection, Judge. I just
That's
don't see
fine.
that in the language here at all.
All right, we don't
Also,
need
we
your
also, we don't know if he had a prescription on count 6 for the bupropion. Apparently it was in a prescription bottle. And I don't know if I'm not really sure exactly what Suboxone is. But if you can have a prescription for it, and he had it in a prescription bottle, then for all we know, he has a prescription for it. So I would ask the court to find no probable cause on count 6. Certainly, if he did not have a prescription on it, or the bottle did not have his name on it, that is the type of thing you would have expected this officer to make very serious note of in his probable cause affidavit. Because that language is sorely lacking in this probable cause
You're repeating
affidavit, I don't
yourself
think
now.
there's any other conclusion this court can come to other than that Mr. Thompson had a prescription for this particular Suboxone.
Your
Any
Honor,
other probable cause objections?
Other than the ones for count 1 through 9, no.
Okay, well, that seems to carry all of them. so.
and Your Honor, histrionics aside, as far in the grand scheme of things, I have no objection if the court finds no PC on count 6.
All right, per state and defense, no PC. On count 6. So on that count, I will ROR.
Jury here.
Anything else? Oh, state, what are you requesting on count 1?
Your Honor, on count 1, I'm going to be requesting a $10,000 bond based on my concern that he was in possession of a firearm in combination with all these other various drugs, including a trafficking amount of heroin. On count 3, I'm asking the court to take into consideration when setting a bond that, as the court is well aware, if convicted of count 3, he faces a 3-year minimum mandatory prison sentence. His priors also include 2011 delivery of cocaine, 2010 unlawful use of false name identity. Nothing further, Judge.
Just so my position's clear, Judge, I did not have a probable cause argument on count 3.
On the 5.8 grams of heroin?
It looks like it was 5.8 grams, yes.
All right, what say you, Mr. Romero, if anything?
Judge, first, before I forget this issue, I know the court referenced and the state referenced that $891 was found in his possession. And I believe the court made a remark as far as somewhere in the PC affidavit, the law enforcement officers allege that Mr. Thompson made a statement that he's unemployed.
I didn't say that. You said, I didn't say that.
Well, I thought you said it.
I
Did. I'm sorry.
yeah, as referring
It's in
to
the report.
Yeah, I didn't
Okay, well, having said that, Judge, Mr. Thompson is working. He works for UPS. He's been there employed for 8 months. He makes about $12 an hour. And from what Mr. Thompson was advising me, within his possession, his wallet, he actually had a pay stub, and he was actually showing that to law enforcement. So hopefully when he gets his property back and it's basically itemized and has that, then hopefully that shows basically maybe law enforcement wasn't 100% truthful. Number 2, Judge, he's also working a second job. He works at MT Plastering. He's been working there for about 10 years, and when she makes $100 per day. He lives in Pompano Beach. Him and his girlfriend mother reside at the same premises. Also, his 6-year-old son. 6-year-old son is attending public school. His girlfriend is working as well. She works for SunPass as a toll attendant. She's been there for about, I believe, how long has she been working there? 7 years, and she's making approximately $13 an hour. As you heard, Judge, he doesn't have an extensive criminal history. I believe from what the state said, I think they referenced 2011. So, Judge, considering his financial resources, his strong ties to the community, what I'd be asking for is on count 1 a $2,500 bond. I'd be asking for a reduction on count 2 from $7,500 to $2,500. On count 3, there's no way he's ever going to be able to afford at this time $75,000 bond. I'm going to be asking for a bond reduction from $75,000 to $10,000. And on count 7, I'm also going to be requesting a bond reduction from $7,500 to $2,500. And on count 8, I'm going to be requesting a bond reduction from $7,500 to $2,500. So if my math is correct, Judge, what the defense is asking for is a total of $38,600 on Mr. Thompson's behalf.
And Your Honor, the only thing I just want to mention briefly, since Mr. Romero brought up and is arguing that the accuracy of the detective's report is in question, the detective mentioned that he was told, that he was told that he didn't have a job, but the detective does mention that he had body-worn camera in use. So,
All right, so on count 1, court's gonna do $2,500 bond. And I'm gonna leave all the standard bonds, 7,500, 75,000, 5,000, 2,500, ROR on 6, 7 and 8, 7,500, 7,500. 8 and 9 are 15,000. I'll tell you what, count 10 on ROR. GPS level 2, no possession of any firearms, ammunition, or weapons. Thank you, sir. Good luck to you. Gennard Murphy. Come on up, Mr. Murphy.
Mr. Murphy, come on up, please.
Mr. Murphy, good morning, sir. You have possession of burglary tools with intent to use. $1,000 bond, count 2 is grand theft between $300 and $5,000. $1,000 bond, count 3 and 4 $100. It's possession of cannabis under 20 grams and obstruction by disguised person. Court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victims in the case with the initials JN and KB. What say you, defense?
Judge, Mr. Murphy unfortunately is not going to be able to afford the $2,200 bond. We're going to be asking for pretrial release. Before I proceed, I'll see if the state has an objection to that.
just in one moment, Your Honor. That 2010 is enough. I'm sorry? I suspect I know what it is. Your Honor, the state would be opposing outright release to pretrial. One, I've been advised he's being ad charged, and while I can't confirm, I suspect I know what he'll be ad charged with based on these allegations. I would also note in 2010, out of Broward, he was convicted of burglary of a dwelling and trafficking in stolen property. He violated probation and was sentenced to 6 years in state prison, released October 1st, 2016.
Okay.
Judge, between Mr. Murphy, he's 26 years old. He was working. He was laying tile for a company. Unfortunately, he suffered a very serious injury, and due to medical reasons at this time, he hasn't worked in a couple months. Right now, his family is helping him out. He lives locally in Fort Lauderdale, where him and his fiance rent an apartment. And she basically does hair for a living. Right now, because of the financial resources and everything they're going through because of Mr. Murphy's medical issues right now, they're really not in a position to post no sort of monetary bond. So that's why we are asking the court to consider releasing Mr. Murphy on pretrial release. $1,000 on 1, $1,000 on 2, ROR on 3, ROR on 4.
The victim contact direct or indirect with JN and KB. Thank you, sir. Good luck to you. Sherrod Clayton.
Mr. Clayton, come on up, please.
Good morning, Mr. Clayton. You have grand theft auto, $1,000 bond. Count 2 is operating without a valid license. There's no bond required. Count 3 is a KPS felony for $1,000 bond.
Yeah, we did that.
Is it a KPS misdemeanor?
Yeah, it's mistakenly labeled as a felony.
Yeah, that's what I thought. Okay, so you have a KPS operating without a valid DL, without a valid license. So you have 1 grand theft auto, 2 counts of operating without a valid license. Court does find probable cause.
Started over.
Do we have a victim's initials? I don't see any victim sheet or a name.
I'll check, Judge.
Court's gonna order no victim contacts are direct or indirect with the alleged victim in this case. $2,000 bond total. What say you, Mr. Romero?
Judge, Mr. Clayton gave me the phone number of his family. I'm calling them after court. He believes that they'll be able to afford to post a monetary bond.
Thank you.
Your Honor, based on the allegations, I suspect this might have been a rental, so I don't think no victim contact's necessary at this
All
point.
right, I'll delete the no victim contact. Car is a rental per state. Thank you, Mr. Linder. Juan Zapata, please.
Good luck, sir. Mr. Zapata is approaching, Judge.
Okay, Mr. Zapata, you have possession of cannabis over 20 grams, $1,000 bond. Possession with intent to sell, manufacture, or deliver cannabis, $1,000 bond. Drug paraphernalia, possess and/or use, $100 bond. Court does find probable cause. Total bond is $2,100. What say you?
Judge, I'm going to be asking for an RO. First, see if the state has an objection. I believe this is his first arrest. If they can confirm that.
Yeah, one moment, judges, to check one thing. Yeah, something is wrong. User error. I have no objection, Judge.
Okay, per state and defense, ROR on all 3 counts.
All right, just be aware, you're going to get a notice in the mail in about 3 weeks. You come back, okay? If you don't, you're going to get a warrant for your arrest.
Thank you, sir. Good luck to you. Eric Skoklin,
And
Did I believe, Judge? Yeah.
how did his, oh, it did
yeah,
post.
and Your Honor,
How did he get $1,000 bond?
Your Honor, just to let you know, it was misbooked.
Okay.
It was misbooked. It's not an aggravated battery
It's a felony battery.
because
with
of
a prior
priors.
conviction.
Exactly.
All right, so court will find PC for a felony battery. Somebody said, who said?
That's the standard bond, yes.
All right, this is Judge Merrigan, felony battery with a prior conviction. So Sheila, that's what I'm gonna find PC for, okay? On count 1. Thank you. Daniel Lino Morales, please.
He's here, President, may Judge? Morning.
Pardon, is bonded?
Yes.
All right, sir, court's gonna find probable cause, you bonded as well. Nathaniel Doherty.
You're relieved.
Nathaniel Doherty,
Mr. Doherty bonded, Judge.
okay, court finds probable cause. John Hamilton Waskowitz.
He's here, present, Judge, and he declined to serve as a public defender.
All right, Mr. Waskowitz, you understand that if you can't afford an attorney, the court will appoint the public defender's office? Do you want to represent yourself? Do you want to fill out an application for the public defender? Or do you have a private attorney, sir?
I hadn't even had a chance to make a phone call yet, Your
All
Honor.
right, so for purposes of now, you actually have a host of charges Do you want to go together and represent yourself, or do you want me to continue this case?
I just want to bond out so I can go to work.
All right, so do you want to represent yourself?
I'll go with a public defender, please.
Okay. All right, so Mr. Waskowitz, you have DUI, alcohol, or drugs. You have a third offense within 10 years. We need to talk about bond. Count 2 is refusal to submit to a DUI test. No bond required. DUI with damage to property or person of another, $1,000 bond. Operating without a valid license, no bond required. You actually have a traffic ticket, driving on the wrong side of a divided highway that's not for magistrate. And 6, driver presents non-current proof of insurance. No bond required on that. Court does find probable cause. What say you, state with regard to count 1?
Your Honor, I'm going to be requesting a $10,000 bond on count 1. Pretrial release with the TAD monitor, no alcohol, intoxicants, no driving.
Okay.
Mr. Waskowitz's priors, he has a 2016 DUI where there was property damage out of Lee County, a 2007 DUI where there was property damage out of Dade County, and I would note in 2002, out of Dade County, his license was suspended for 6 months. It looks like there was a DUI arrest. I don't know what happened with the case, but his breath alcohol was above a .08, resulting in the automatic suspension. Just one moment, Your Honor. Also noting, he has DWLS's, the DUI in 2016 in Lee County. He was also driving on a suspended license at that time.
So the 16 and 17 involve crashes,
Yes, both his priors involve crashes, Judge.
okay? I'm sorry, you said how much monetary bond?
10 on 1.
Any other special conditions?
Pretrial, TAD, no alcohol or intoxicants, no driving.
What say you, defense?
Judge, I was just speaking with Mr. Waskowitz as far as what the state was recommending. He's in total agreement with that. He gave me the phone number of his wife. We're going to be contacting right after court. Basically, he's the sole provider of his home, so he's scheduled to work tomorrow. He just wants to make sure he can hopefully bond out by today and then be placed with the TAD monitor so he can be released and
Do we
go to
have
work
TAD
tomorrow.
monitors? I know yesterday Ms. Wiggins said that there were 5 of them, and I think we put 2 people on them. Can you just double check? All right, go ahead.
That's it, as long as he can be out today so he won't lose his job, and then, because if he does, there's a spiral effect, he might lose his home and everything like that. But
Well, I
he's in
can't,
agreement with everything.
I can't control pretrial services when they put the monitor on him. I mean, he should be able to do it. He's gonna have to post his bond first. So I'm gonna do a TAD monitor, no alcohol, intoxicants, random testing at his expense, prescription meds allowed as prescribed. So there's no driving until further order of the court. There's a $10,000 bond on count 1. Count 2 is no bond is required. 3 is 1,000. 4 is no bond required. 5 is not for magistrate. 6 is an NC, so it's no bond required. So those are the 3 conditions. So I'm gonna put him on, Ms. Patrice, do I have to put him on standard pretrial for alcohol, for the testing? I have to put him on pretrial. No, I meant, but I need to put him on some type with the TAD, right?
Correct.
Okay, just double checking. All right, so I'm gonna put him on standard pretrial supervision instead of a GPS. He's to report within 24 hours of his release. He's to call in twice a week. Report 1 time a month in person. Thank you, sir. Good luck to you. Your total bond is $11,000. It has to be paid before they'll fit you with the TAD monitor, okay?
For the record, we have 6.
Okay.
Oh, you do? Good, thank you. All right, thank you. All right, so does anybody have any questions? Okay. All right. Benjamin Katz?
Bond's posted.
Did you say Benjamin Katz, his bond was posted, Judge?
Yes.
I mean,
He's reset for the PM.
That's the one Mr. Jellen's representing him. You can take a couple. All right, John Callaghan,
His bond,
Mr. Callaghan is here present, Judge. I mean,
He
come on up,
bonded?
sir.
his bond has
Oh,
been posted.
Your bond, so I don't have to call your mom. She already did.
Riani Holloman.
Mr. Holman is here present, Judge.
All right, you have aggravated battery, sir. You need to talk about bond, aggravated assault with a deadly weapon without intent to kill, and driving while license is suspended without knowledge. Court does find probable cause. Court is gonna order no victim contact, direct or indirect, with the alleged victim with the initials SSB. And I am gonna require you to maintain 1,000 feet minimum distance at all times. What say you state on count one?
Your Honor, on count one, I'm gonna be requesting a $20,000 bond, $5,000 bond on count two.
Tell me why.
First, 2013 aggravated fleeing, eluding at a high rate of speed, grand theft auto. He was arrested a few months ago on 2 counts of domestic violence battery. They were dropped November 8th. But also, Your Honor, just noting, one, this incident was not only witnessed by the arresting officer, but another witness. It would appear that Mr. Holloman intentionally ran down this woman in this garage. He struck her with enough force that she, one moment. Causing her to land on top of his hood. And even after she fell off, he tried to strike her again. And this was, again, all witnessed not only by an officer, but by an independent witness who gave, I believe, gave a sworn statement. Yes. No, that's the case. I just said it was dropped.
Says the defendant came to a complete stop in front of the victim when they heard loud revving coming from the vehicle engine. Okay, go ahead.
I have nothing further, Judge.
Judge, believe, what the state suggested, $25,000, something Mr. Holland is not gonna be able to afford. He's 25 years old, been living here his whole entire life. He's working, he works at a restaurant called Missions Barbecue, which is in Davie on University. He's been there for about 10 months, making about $9 an hour. He lives in Lauderhill with his sister. They've been renting at that apartment now for about 3 months, and their monthly rent is about $1,200. He assists his sister. His sister depends on him. She is deaf. She is on disability. Besides being basically his sister's caretaker, he has a 5-year-old son, which he financially assists his girlfriend to provide for his son, Judge. So as all that to me indicates that really he doesn't have the financial means to post a $25,000 bond. What I'm going to suggest, Judge, is a bond reduction on count one to $5,000 and $2,500 on count two. That would be a total of $7,500. And I do understand the allegations are serious, so we have no objections on top of the monetary bond from $7,500 for Mr. Holland to be released also on standard pretrial release.
All right, court does have a concern for the safety of the victim in this case and the community. States here that in addition to what I said before, after there was a revving of the vehicle while the victim was standing in front of the vehicle. I don't know if they were standing, but they observed the vehicle accelerate forward and drive into the victim, who was still standing, that's what it says, in front of the vehicle. I observed the vehicle strike the victim, and the victim landed atop the vehicle's hood. Based on the nature and circumstances of the offense charge, the weight of the evidence in this case, and the defendant's past and present conduct, the court's gonna order $25,000 bond on count one, $35,000 on count two. No, count three, the driving while license is suspended without knowledge. There's no bond required for that. Court's gonna additionally order no victim contact, direct or indirect, with the alleged victim SSB and maintain 1,000 feet, GPS level 2, and no possession of any firearms, ammunition, or weapons. Anything else, State?
No, Judge.
All right, thank you very much, sir. Good luck to you. Christopher Pinky. Where's Christopher Pinky? Says PC in absentia, medical reset.
Yeah, I don't know.
Bye-bye, good luck. Okay, I guess it's a reset.
Yes, it has been.
And then we have Joshua
Oh,
Brockford.
I don't know if it was a medical reset today. I was
Well,
referring.
I'm assuming it is. He was
He
at
was at North, I believe.
North Broward, you there?
Your Honor, we have, one more person, Campbell.
What about Pinky? I just want to confirm it's a medical reset, North Broward?
1 second, please.
He was at reset yesterday.
Yes, he's a medical reset today also.
Okay, no problem. And Joshua Brookhart?
Medical reset, Judge.
We'll see you back at 1 o'clock, Mr. Romero. George Campbell.
North Broward.
No power, Your Honor.
Hi. All right, Mr. Campbell, you have an ad charge, count 7, lewd lascivious exhibition presence for 16, someone under the age of 16. Court does find probable cause. Court's gonna order no victim contact, direct or indirect, with the two alleged victims. They have the same initials, AI and AI.
Judge.
Sir, you have the right to remain silent. Anything you say or do can and will be used against you. What say you, State?
Your Honor, do you still have the paperwork I provided yesterday?
It's all attached.
Okay, good. Thank you. Your Honor, I do have a concern based on not only the allegations of this case, but the allegations for his pending indecent exposure that he's currently being held on a $5,000 bond on for violating pretrial before Judge Evans. They share similar allegations in both cases. I am going to be requesting a $50,000 bond on this count. No contact with minors, pretrial release with the GPS monitor, level 2.
Sorry, how much bond?
50,000.
Okay. Mr. Reedy?
Yeah, I don't think Mr. Campbell could make $50 worth of bond, Judge. Right now, he's got a total bond of $5,800 on the outstanding charges that he has. But he's not able to post that, so he does have some court dates coming up in a couple of days in front of Judge Evans. There's another court date coming up early next year. I really don't think it's gonna make much difference what bond you set, Judge, to be quite honest. I'd ask for a $1,000 bond.
Court has a concern for the safety of the community based on the allegations and the totality of the circumstances. I'm gonna set his bond at $25,000. No victim contact, direct or indirect, with the two victims. AI. Court's also gonna do a GPS level 2. Thank you, sir. Good luck to you. Kevin Seminis. It was a medical reset, North Broward, from yesterday. So court's gonna make a finding of probable cause.
No, that's,
I'm gonna find PC in absentia unless I hear an objection.
No objection.
that's Terry. That was reset for the afternoon.
Huh?
Jimmy Terry was reset for the afternoon.
Yeah. Mr. Jellin has 2 cases this afternoon. All right, PC in absentia. Bring defendant back to court for bond and release conditions. So I am finding probable cause. Unless you'd like me to set the bonds at $1 each, it's up to you, Mr. Reedy.
That's fine, Judge.
All right. So I'll set the bonds at $1 each. Okay, so I'll put that you waive his presence, okay?
That's fine.
All right. And Ms. Patrice, I have these for you. Thank you very much. Oh, one more, okay. All right, here you go.
See you folks at 1.
Thank you.